Yeah. I don't know, you'll have to look it over. Do what? Yeah, Paul, as soon as I leave you. Right. You all set now? It's 9:01. Bring the regular September board meeting to order. Shirley, would you read the invocation, please? I'll save the invocation.
Pray with me, please. Dear Lord, we just thank you so much for the recent rains. We thank you for the cooler weather. We just praise your name, dear Lord. We ask that you bless this meeting today and help those set on the board to make the correct decisions to benefit everyone at the fort. We thank you for the peace that we enjoy here at this beautiful place that we live, and we pray for those that are in harm's way. We ask that you bless their families while they're away, and we just thank you so much, and this prayer is in the blessed name of your Son, Jesus Christ. Amen.
Amen.
I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
One little correction out of order. I did not establish a quorum. We have a quorum. Any announcements and correspondence? Yes.
To the Fort Clark Springs Board of Directors and Director of Operations, Jody Stevens, from the Fort Clark Springs Community Council in reference to Fort Clark Day. Fort Clark Springs Community Council requests permission to use the large billboards facing Route 90 at either end of the fort to publicize Fort Clark Days beginning in December 2012. The 2013 dates for Fort Clark Days are March 1st and 2nd. For the past 5 years, the Community Council has donated the entire proceeds of this event to the Fort Clark Springs Historic Buildings Preservation and Restoration Committee. To date, this has amounted to $57,289.95. The Council has voted to continue donating 60% of the net proceeds of Fort Clark Days to this restoration effort. The remaining 40% will be directed toward updating equipment used to put on the event and to continue the interior work on Shafter Hall. We believe that use of these billboards will enhance our fundraising efforts and bring much needed positive attention to Fort Clark. Thank you for your consideration. Sincerely, Judy Winchell. And we have another one to the Board of Directors from the Community Council. The Fort Clark Springs Community Council at their September 8th meeting voted in the majority on a motion by Woody Hornberg to request that Fort Clark Springs Association place a plaque on or near the empty saddle statue commemorating the contributions of L.B. and Ralph Beard to the betterment of Fort Clark. As you know, Mrs. Beard recently passed away, and the council feels that this is an appropriate way to recognize her volunteer service. Your favorable consideration will be appreciated. Sincerely, Judy Winchell.
Thank you. At this time, I'd like to have a presentation from the legal firm of Langley and Bancroft, Inc.
I'm going to take the microphone if that helps.
Unless you got a loud voice. What? Do we have a minute? Oh, sorry.
Yes.
Did we read the minutes? You're right. 1 minute, Eddie.
Yes. Yes, sir.
Would you please read the minutes?
You want to read them?
One. Yeah. Did you read them already? Yeah. Yeah. Did everybody read the minutes? Is there any corrections?
Just for the record, make sure that which minutes you're addressing. That would really help.
The last meeting.
Okay.
No corrections? Do I have a motion to accept the minutes as they stand?
I move that we accept the
minutes for the last meeting. Do I have a second? All in favor? Motion passes. Thank you. Sit down.
Do we also have special meeting minutes to approve?
Right. Yes, we do.
Oh.
Do I have a motion on it?
Oh, okay. I make a motion that we also accept the minutes of special meeting of September 1, 2012.
Right.
I would second that.
All in favor? Thank you. Motion passes. Now we can get on to where I jumped over the... Would you go ahead, sir?
Thank you, Mr. President. Members of the board, we serve as legal counsel for the Fort Clark Associations, and recently there was some changes that were enacted with the passage of certain legislation that affects the association. And at the request of Janelle and Jody, we came and addressed some of those changes. And I think at the end of our very fruitful discussion with respect to these changes, we figured that it would be best to address the board with respect to the Open Meetings and the Open Records Act and the changes that were now contemplated under the new legislation, and how that would affect not only the board but the members as a whole. So just briefly, there's some details here that I would want to go into. If anyone has taken the time, I'm free to address any questions that they may have. But in essence, I think because of some of these associations in the past 5 to 10 years were really taking advantage of the members, and we're really keeping certain information from being disclosed, and it was being applied unevenly throughout the state of Texas. And I think the legislature determined that this was in fact a problem. There was a number of lawsuits that stemmed from that. Our firm is based out of San Antonio. We have about 51, 52 attorneys. We have 2 attorneys that are specializing a lot in homeowner association issues, because we were having members that were approaching our attorneys and telling us how they were being taken advantage, or they were being unnecessarily affected through dues or fines or certain assessments where they didn't even have notice. And so we've been personally privy to what's been going on to some of these members. And so I think that's the reason why the legislature decided, let's implement some sort of policy so that we can have some sort of protection for the members, and also for the board, so that you guys will know what exactly you need to do. Because as it was, every association had its own covenants and restrictions and bylaws and procedures, and so every association was out there, and really didn't have much guidance. So one thing that you ought to take from this is that the legislature has basically asked you to be more in line with what a municipality or a governmental entity would do. We serve as legal counsel for a number of governmental entities: the City of Eagle Pass Water Works, the Housing Authority, City of Brackettville, and some other municipalities in San Antonio as well. And so we're very familiar with the Open Records and with the Open Meetings Act. And in essence, about 80% of what you see, what already needed to be complied with by municipalities, you are now as an association being asked to do the same thing. So everyone follow me? Now you're more in line, and you're being asked to act more like a municipality, like a governmental entity, when it comes to open records and when it comes to open meetings. So let's break that down. Let's first address the open records. Basically, you're taking, and the legislature has asked that the association take the position that it shall make all books, records, financial information disclosable or open to its members. There's a noted exceptions, and I'm going to try to go through them. But in essence, whenever you receive, now these owners have a right to receive this information. They must request it in writing, and it must be by certified mail. And we've already established somewhat of a protocol with Janelle and Jody, so that when that request comes in, it also, at least the first couple of times while we get our our feet wet and try to figure out, is this is how we're going to be responding to them. At least get legal involved right away so that we can make sure that we comply with all of the new provisions, since this is basically new law.
Why does it have to be by certified mail? Why can't you have like a file stamp at the front desk that they received that and you get a copy of that?
Because the legislature specifically pointed out that it needed to be by registered mail. It's not Janelle or Jody or you member. It's the actual legislature.
That is clear that the only way you can make an open records request is by certified mail.
Correct. Now, there's and I'll go through some of the exceptions on like voting when we go to the Open Meetings Act and the annual election voting and how that can take place, because it doesn't require actual certified mail whenever you're voting by mail to be returned to you. There's other stuff to it. But yeah, with respect to open records, we saw that also kind of weird or different from what is asked of municipalities, because technically in a municipality, let's say the city of Eagle Pass, and you wanted to request records from the city of Eagle Pass, you could go personally and fill out one of the forms that they have there, and it actually would be file stamped, and that would be sufficient. But for some reason, and if you look at the legislature, it just says it has to be by certified mail. And so, again, this is new law. This is new territory that we're going into. And the only thing, and that's what we told the ladies when we met with them, the only thing that we can go by is precedent. What has been established before? How have things been decided before, so we can provide guidance to you as to how to respond to this certain request that is made of you. And the way we do that is through Attorney General opinions that are handed out by the state of Texas. So that's all we have. But we know that there's some specifics here that are different from what is required from a municipality. I would have taken the position of, if a person walks in, that will also be sufficient to accept that person, and if they make their request in writing and you file stamp it, that should be sufficient. But as far as what are the requirements under state law, it has to be sent by certified mail.
Excuse me, sir, could you clarify for me at this point? There has been much discourse as to whether we're governed by the new statutes under the property code or the other, what is that?
Homeowner.
Attorney General, Open Meetings Act?
Right. And which are we supposed to be following?
You're going to follow the property code because it's specific to homeowners associations.
And especially ones that are in a county like this that is not adjacent to a county with a huge population like San Antonio.
That's one of the exceptions.
Am I understanding
Correct,
it properly? Yeah. Thank you.
A municipality is governed by by Chapter 552 of the Local Government Code. The City of Eagle Pass, in order to respond to an Open Records Act request, would have to go look at Local Government Code Chapter 552 to figure what its response time is and all of that. Like I said, a lot of the stuff that's in here that now is going to apply to you under the property code, and a lot of the things that the association needs to do with respect to requests being made by members, about 80% of that, they just basically cut it from Local Government Code Chapter 552 and pasted it to the property code. But there's still differences and little unique tweaks that they made, and those are the important ones, because somebody can go to the Local Government Code Chapter 552 and think, oh, I'm entitled to this, and I should get this within this specific time period, but that really doesn't apply under the property code to associations. So it's important that we be looking at the correct application of the correct act to apply it properly.
Thank you.
So yes, you are governed by the property code, and it's not Texas Local Government Code Chapter 552, which is different.
Thank you.
Okay?
Thank you.
So hopefully that everyone understands that big, because I can see already, we are going to find differences, and if a member's looking at the wrong act, you may misinterpret what exactly you're entitled to, or what the rights of the members are, or the actions that are supposed to take place by the board. Yes, sir.
What is the response time allowed by law from the time we receive the certified mail to the time you get
That's also something that's very similar to the Texas Local Government Code, which applies to municipalities. It requires 10 days, okay, for the board, in this, the director to respond with respect to your request. It doesn't mean that the material needs to be provided to you within 10 days. There's a difference. Some of the stuff and some of the requests that are going to be made, you don't have the material, but yet the board or the director should not just should just not ignore your request. It needs to submit something to you in writing about your request. Yes, I do have the information. No, I don't. But I do have it in this format. Also, if there's some exceptions, like some of the information, let's say you ask for a specific employee's personal file. Well, that's an exception to the Open Records Act. And we can abstain from producing that information because the legislature specifically said do not provide personnel files of employees. And so, but you would be entitled to the director sending you a letter or legal counsel.
To a response by 10 days, but not necessarily the information. So how long do they have to give you the information?
If, for example, we need to make an estimate, if the information is so voluminous in nature or we need to gather it from offsite storage, we need to provide a detailed estimate of time as to how much time it would take, and also if there's any fees associated with your request. The association can also ask, because there are fees associated and they may be, up there, we may ask for upfront payment, and we don't move forward until you submit payment. Now, we're supposed to keep detailed records. So let's say I tell you it's going to take me $100 to gather the information, and you come and tender the $100. And at the end, it only costs us $50 to go gather the information as you requested and produce it to you, as well as the copies that we can charge to you under the government code. Well, I'm supposed to reimburse you the other $50. Okay? Now, if it's higher, let's say you only submitted $100, but it turned out that it was $150. Within 30 days, we're supposed to let you know that there's still a balance and you owe the board or the association $50. And if you don't pay those $50 within 30 days, then they can be assessed to you in your regular assessments. Okay?
And is there also a fee schedule set out in this like there is in 552?
Correct. 552 points you to a certain other section of the government code where it tells you how much we can charge you for a copy, how much we can charge you for, let's say it's easier for us to produce the information in an electronic format, either through a flash drive or a CD, and it specifies the costs for that. Those are the ones that we need to follow. And I'll get to it because two things that the board needs to be adopting in the near future, and we're going to be working with Jody and Janelle, is the records production and copying policy. And it's just basically, we'll formulate the resolution that you guys will consider and hopefully adopt, where you just say, we're going to follow, I think it's 31 TAC or something like that of the government code. That specifies all those costs that we can charge. Yeah, we just can't say, you know what, everybody else charges you 10 cents per copy, we're going to charge you $5 per copy. We can't do that. We need to comply with state code. And the second thing that we're going to ask you in the near future to also adopt will be the retention of records policy. How long must you retain certain records? And the legislature specified certain records must be retained for 7 years, and we'll go down through it. Some records need to be retained for 5 years, and some other type of records need to be retained for 4 years after let's say the minutes. I think it specifies 4 years from after the minutes were approved. We need to retain those.
And also a records officer, correct?
Excuse me?
Also a records officer, an individual?
I didn't read that section, but I'm sure that we would want to have somebody that would be like the custodian of records. Definitely, yes. It's a good point. Janelle?
And I apologize that had previously been provided to you, but our previous board had adopted the open records, the copy and policy, the retention policy, those have already been adopted in the
Oh.
form of resolution, so I will get you a copy of those, and I apologize if we.
Perfect, and that's great, then
It
you're,
may need tweaking a little bit, but.
then you're that far ahead, and I'm sorry we didn't address that, or maybe we did, and we talked so many things that I forgot to. But yeah, when I was just going through it, I wanted to make sure that if we haven't adopted it, that we adopt it. That's great. You're that much far ahead then. Okay. We talked about the submittal of the request needs to be by certified mail. It needs to detail the information that is being requested. And also, if you all are members here, you must be specific in your request and have either an election that you're going to inspect the records or that you want copies. In your request, you must make that election. I want the ability to go and inspect the records, or I want copies of the records. You need to let the association know which election you're taking, one or the other, an inspection or that you want copies. Okay? To address the response time, we need to do it within 10 days. If unable to provide or produce those records, we need to specify the reason, as I was informing the gentleman here. The inspection of the records, let's say that you choose, your election is to inspect the records. It must be done within normal business hours. The association does not have to stay, for example, if your normal business hours are 8 to 5, they don't have to make special accommodations for them to keep an employee here past 5 o'clock so that they can kind of be there guarding the books or taking care of them. And they don't have to make the books available to you after 5 o'clock if normal business hours are between 8 and 5.
Eddie, can I interject 1 second?
Yes, sir.
It's 10 business days. Let's clarify that.
Yes,
10 business days.
correct. 10 business days. Now, specifically, the legislature has informed in the passage of this act, you're not required to produce or release for inspection any records with respect to the violation or the history of individual owners of an association. So let's say I'm a member and I want to know, and you're also a member, and I come in here and make a request. I want to know how many times you violated the association rules or guidelines. I wouldn't be privy to that information unless you specifically waive the requirement. You say you can produce that to Eddie. That's fine. Unless you do that, you would not. I would not be entitled to that information. The owner's contact info other than the address. So a member can request the contact information of all the members in the association, but the association must only provide the address. It cannot provide cell numbers or home phone numbers or emails with respect to the individual members. Also, the association is not required to release for inspection owners' personal financial information or records of non-payment or amounts due to the association. Okay? It shall not disclose either information about a specific employee or the personnel file that we already discussed. You do not have a duty to have to release or make available for inspection those records. Now again, we'll take this on a case-by-case basis as the request for records comes in. And so again, I'm just giving you a general overview. But as it comes in, the easiest thing for you to do is to sit down with Katrina or me or one of our other attorneys so that we can help formulate a response. The exception to what I just said is if we are being court ordered, if there's litigation and there's a court order signed by a judge, then we need to release that information. Okay? Okay, we talked about the adoption of those two policies, which Janelle just informed me about. The retention policy that's in place, for example, and that's contained under subsection L, requires, for example, financial books and records to be retained for a period of 7 years. Account records of current owners shall be retained for 5 years. Contracts with a term of 1 year shall be retained for 4 years after the expiration of the contract term. Minutes of the meetings, it's actually 7 years, not 4, that we need to retain them, okay? And I really like your idea. I think we need to have something, if it's not already in there, we need to establish who the custodian of these records will be so that that person is the one in charge. Tax returns and audit records shall be retained for a period of 7 years. Okay? And that's all I have with respect to the open records. I can ask any other, I can try to answer any other questions that you may have before we go to the open meetings requirements. Yes, sir.
Question I would have is that we at the members of the association, we have been refused answers to questions that we have had in the past about lawsuits that the association has had to pay, or the association has to make some kind of a deal with the lawsuit and have to put out X number of hundreds of thousands of dollars that is coming out of the members' dues, and we have been denied information as to what the settlement was. And to this day, I have not heard about a recent settlement and other settlements in the past that we have been kept in the dark. So where do we stand? The board whom we appoint, we vote in to represent us and represent the association, and yet they withhold information from where or how much of our money is going out to these lawsuits.
I can understand the frustration, but at the same time, I think you need to take into account that sometimes the parties may enter into an agreement that requires for the information to remain confidential, and under the Act, it allows for the association not to disclose that information for privacy purposes. And so that may be a reason why you're not being provided that information. But I can understand the frustration, because now you're being asked to fork over maybe a little bit more money from your dues. But the Act specifies that pending contemplated litigation, for example, we don't have to go into details, and we may go into executive session to address pending or contemplated litigation and not have to disclose the amounts. And if there's a confidential agreement, then even more of a reason why.
Well, wouldn't this come under the Freedom of Information Act of September back in 1970s? That the law requires that the public records, or this records, would be made public to the person that would request it? Would that come under the Freedom of Information Act?
If you heard me with, I think, board member, what is your name? Keely, she asked me that specific question. Where do we fall now? Do we fall under the Open Records Act and Public Information Act of the 1970s, which was statutorily written into law under Chapter 552? Do we fall under that, or do we now fall under the Property Association? And it's the Property Association that governs us.
Well, no, the thing is that because of this lawsuits and thousands of dollars that have been paid out of the association dues that we pay, but we are required to pay on a monthly basis, and therefore the association is going in the hole, and then they turn around and ask for an increase or supplementary assessment to make up the difference, and we don't know why. We don't know how much, for what reason. So what, we should have some kind of right to be able to, the information to be exposed to us, so that we'll know, hey, okay, you're asking for an additional, so why? Don't just come up and ask me. And another point is, can we refuse to pay that assessment because they're refusing to give us the information?
To answer your last question, no, you cannot. The Act does not give you additional rights or the ability to refuse to pay certain assessments just because you think you were not provided information. So the Act doesn't give you or grant you that right. Secondly, I can only go back to what I already told you before, which is for privacy purposes or for confidential reasons, especially if the parties, the litigants entered into a confidential agreement, it does not have to be disclosed either. However, you are entitled under the Open Meetings Act, which is what I'm going to go into now. You are entitled to be notified if there's going to be a discussion and consideration of new fines or new assessments. Before, like I told you at the beginning, that the associations all throughout the state of Texas were all over the place and that they had different bylaws and procedures in place. Now it requires that if a board is going to consider additional assessments of its members or impose additional fines or increase additional fines or even decrease fines, it must provide notice to its members. And it has to be at the minimum, if it's posted in a conspicuous place, it has to be within 72 hours from the date that the meeting is going to be held. If it's going to mail you that notice, it needs to be at least 10 days before the meeting is to be held.
Well, see, the thing is also that because we're not informed of the additional expenses of, for example, a lawsuit that have happened, and so they may come up with an additional special assessment to make up the deficiencies, and we don't know whether it's because of the lawsuit or because of embezzlement.
That's
So where do we stand? Either it's embezzlement or is it a lawsuit?
well,
How about its expenses?
yeah,
How about your electric bill going up?
I don't know how to, you would be privy to financial records, and if you, let's say for example, you specialize, I'm just giving you an example, I don't know what you do, sir, but let's just say you're an attorney. So your specialty is to know the law, but you have no idea, just like me, on how to follow books and financial books, let's say. You can designate your CPA in your request to review or to inspect the financial records of the association. You can designate your CPA or somebody else within your family or any agent that has that experience, so that they can come and look at that and determine whether there's embezzlement or not, if you can't do it. But to say that the additional assessments are just because of embezzlement, I think that's a far type of argument to make without any support. So
Well, it is possible, you know.
Could we,
Probable.
excuse me a minute,
It's very probable, yes.
could we not carry this on and on and on and on a subject that isn't even valid because it isn't happening? You know, speculation is one thing, but let's stick to what the gentleman is trying to present to us.
Okay, I've got a question for him. What I'm hearing is that if we want any information, we have to send a registered letter to the board, to the office, requesting specifically some information that we don't know is. Just like they several months ago, they spent money to hire private detectives for some reason that we don't know, and for some reason we don't know who they paid the money to.
That's what I'm saying.
So what
Let me interject real quick,
set
sir.
behind? We don't know what information we want, but we
Please. We're
Oh, I don't have the right
we're
to
still
talk.
going down a path that is really ridiculous because nothing like that happened. You think it
nothing
did.
like that
No, it
happened?
The
didn't.
money was not spent,
No,
sir.
it was not spent. We said that in a meeting.
And
here.
actually where the money went is to hire attorneys so that we can get all this stuff straightened out, so everybody can have this opportunity to learn together. It did not happen, no private detectives, and because of that, the reason it was stated, because my information was leaked out of here before I ever got the job. That's where that came from. And this is where I chose to spend the money, is for this right here, so
So
everybody
you
can get
spent
it.
money on a lawyer instead of a private detective?
Yes.
No, she
No.
Our
didn't.
money.
I didn't.
We did.
We have attorney fees.
Okay, we spent money for
Is this
private
not
detectives,
educational for
a
you?
lawyer instead of a private
Is this not
detective.
educational for you?
Okay.
It's a lot less money.
just for the record, I want to, we have not hired any private detective with respect to this. So just, I want to address that. The law firm Myself, my partners, we have not hired any private detective on behalf of the association. And we have served as attorneys for a number of years for the association. So it's not like we were just hired last month either.
It's still our money that we spent that we don't know why it was spent or what.
It's being spent to inform you as to what you should be doing.
You're not listening. You're not listening. The gentleman is trying to tell you something. Would you please listen to it and save your comments until he's done? I've asked that before. No, I'm not gonna. Please, until he's done, let him go into the open meeting.
I just want to say, it was well spent, very informative, and I really enjoyed
Right.
the presentation.
Thank you, I appreciate that. But please, let's hold back everything else for now.
He asked for questions.
Would you please?
Yes, sir. Let's jump now to the board meetings, okay? And what the requirements are under the new changes under the property code. With respect to open board meetings, the first section of the legislature's act addresses what a board meeting and defines what a board meeting would be. Again, 70-80% of what is already part of the meetings and the requirements for municipalities and governmental entities, what they did, the legislature just basically cut it and pasted it to apply to the property associations, similar to yours. Okay? Something that's hugely different from what a municipality or a governmental entity is supposed to comply with. For example, any meeting to deliberate by the board in a municipality, let's say like the city of Eagle Pass, any sort of meeting of a quorum of its members needs to be posted. And it requires 72 hours notice if it's posted in a conspicuous place. The act, which addresses the rights and responsibilities and the duties of an association, actually makes an exception. And it specifies that for any routine administrative matters, you do not have to post a 72-hour notice of the meeting. And that's huge. I mean, that is super huge in relation to what is required of a municipality under Chapter 552 and what is required of you as an association under the property code.
So that would, in effect, take the place of where in 552 it says even administrative briefings.
Correct.
Here you're allowed to do administrative briefings.
You can meet with your director and the board, and you can even take action on routine administrative matters without having to post notice of the meeting. That's huge. And a lot of people may be misguided into believing, or if they read again, we go back, they may read Chapter 552 and think, oh, the association needs to comply with the notice. And I just heard that the members and Jody met last week and there was no posting whatsoever. Well, so long as there was a routine administrative matters that were discussed, an action that took place on routine administrative matters, you're okay.
The minutes have to be recorded and presented at a future date?
Correct. At another meeting, you need to have some general description as to what the decisions were during that routine administrative meeting. Yes. So we can have some sort of, you can understand what the legislature was trying to do. They were trying to keep some sort of way to formalize whatever took place in that meeting, even though it wasn't posted and the members weren't informed of it. Now, also, you have any unforeseen emergency or urgent necessity that requires board action, you do not have to comply with the posting requirements and notice to members under that situation.
How is that written so you don't use that power?
Again, because this new act just came into place at the end of 2011 and applies from 2012 forward. The only thing that we have as precedent so that we can figure out what is an unforeseen emergency or what is an urgent necessity is to look at the AG opinions, the Attorney General opinions, to see how they defined an emergency or an urgent necessity, so that we can apply it also here. That's the only thing we have. That very same question was asked by one of these ladies when we met with them to address this issue, And we've specified, the only thing that we can fall back on is look at those AG opinions. So whenever you feel this is an emergency, and I think we can meet without without posting or without notice to the members, at least at the beginning, what we would recommend, pick up that phone. We're not that far away, and even closer by use of a phone or an email, and just say, can this fall under an unforeseen emergency or urgent necessity?
Something that needs an act right away.
Yes.
And how many board members have to be present to allow that to be justifiable?
You still need a quorum.
That's great.
Yeah, you need a quorum.
What type of effort do you need to show that you made good conscious faith to notify all of them?
There's no discussion of it in the act. And
So
again,
if
we
you were to use that act, 3 board members could meet anytime they felt like it and generally make the decisions for the board.
yeah, then they would be subject to criminal and civil penalties if they do that.
That was done.
If you can prove it.
Correct. Yeah, you'd still, I mean, it wouldn't just be automatic. Somebody would, an aggrieved
There's no
person.
measure in there that says you'll have to notify everybody 24 hours in advance or not.
And not in an emergency.
Correct.
You do it right away, try to contact everybody, bring them together.
Yes, that would be the key.
If everybody acted in good faith.
Correct.
Well, that's the whole idea.
Okay, now, let's go. Any routine administrative matters, again, would not, or unforeseen emergency or urgent necessity would not require that actual notice be sent out to its members. Now, but it does specify, the Act does specify that the board may not, without prior written notice, under the 72 hours or 10 days by mail, may not consider or vote on fines, damage assessments, initiation of foreclosure actions, initiation of enforcement actions, increases in assessments, levying of special assessments, appeals from a denial of architectural control approval, and a suspension of a right of a particular owner. Okay? Those are specific. If the board is going to take action on any one of these 7 things, you must provide notice and post. Okay? So, again, this is new. The easiest thing is just working together with your legal counsel. I think will be able to effectively address this and make sure that we comply with the requirements. If just like governmental entities and their members and their boards, let's say they go to a statewide seminar or a convention, and there's a quorum of you that attend, that is fine. That's an exception to the Open Meetings Act, and it actually provides also. It almost has the same language as under Chapter 552. If you all go to a convention or a seminar, it falls outside of. You don't have to be posting, and also there's a requirement that for the most part you try to hold your meetings in the county in which the association is located. So you can't. The exception would be, and we'd almost always tell you, please don't say that you're going to have your next annual board meeting in Las Vegas. Something like that. You have to do it in the county so that I mean, you can understand. Some of this is basics. You can understand why. You want to meet where your members are going to have access to you, and they can also, participate in the meeting. And that's in essence what the legislature was trying to do. The Act, another big change or difference from Chapter 552 and the Property Code and this Act. The City of Eagle Pass, when it goes into executive session, it can only deliberate. Let's say there's a case that the board needs to discuss in private. There is only deliberation that can take place in executive session. The action, whatever action that may be, they need to come out of executive session and back into open session and take action there. Okay? There's a difference in the act with respect to the association and the board. You have the ability to not only meet in executive session under that same scenario, but also to take action in executive session. And then your only duty at that point when you come back into open session is to give a general description of the action that was taken. You don't have to be specific. You don't have to provide specific numbers. Oh, we agreed that our counter offer is going to be between $10,000 and $20,000. You don't have to give that or any of that. Or if you settled for $10,000, you don't have to say that you did that. Just that the case styled Eddie Morales versus Fort Clark Springs Association was settled on this day.
Great.
That's huge. Again, there's a big difference. And again, you may have some folks that are misguided or not completely knowledgeable as to what act to look at, and they may be looking at the wrong act. They may be looking at Chapter 552 of the Local Government Code, and they may be coming to you and saying, you can't do this, but that's not correct. Under this act, which applies to you, you have that right and that ability. You can go into closed session to discuss personnel, to discuss pending, just like I said, pending or contemplated litigation, to discuss contract negotiations, to discuss communications, confidential communications with your attorney, to discuss matters involving invasion of privacy of individual owners. From reading the act, and if you read it in its totality, it seems to provide some protection so as not to I guess some of these associations, whenever a member started inquiring, they would turn around and kind of maybe attack or produce a lot of information out in the public about that specific member, which would not be cast them in a positive light. And there's some privacy implementations here under the Act that protect members. So we just need to be careful not to disclose private or confidential information of members. And also finally, matters to remain confidential by affected parties and by agreement by the board. So if a member comes to you and says, I want to address this, but I really want it to be in confidence, and you enter into a written agreement that it's going to remain confidential, whatever item that was addressed between the member and the board, then that also can be held in executive session. And when you come out of executive session, you don't have to give the finer details. You just give a general description without naming the member. I already explained, when you come out of executive session, you summarize what took place in executive session. There is absolutely no breaching of privacy of individual owners. And if there were expenditures that were made in executive session, you need to disclose those expenditures.
So if in executive session the board voted to expend money on some given thing, they would have to inform the public of that when they get back out?
Yes, but again, then we fall, what type of expenditures? For example, if it's to settle a lawsuit, my position would be as legal counsel to...
Pay, for example, or...
Correct.
That has to be...
That, for sure, I would tell you, yes, for a road to be paved or to repair the damage to the this building and the roof, something like that, yes, you need to provide a general description of the expenses associated with that expenditure. But for a case to settle, it would be my position and my legal advice to you that should remain confidential. Your let's see what else here I can cover. That's it. I have that there's an annual meeting that needs to take place, but I'm sure you all are aware of that, and you hold your annual meetings, right? And there's certain requirements that there's going to be voting or votes that are going to be cast for some reason, and we're going to need to, unless you already know it and we just haven't discussed it, hopefully you can inform me here. But if a member provides their email to you, we're supposed to start keeping a database of that email, and if necessary, whenever we're going to have an annual meeting, we need to notify them by email also. I guess they're asking us to get into the 21st century. Yeah. So let me know if you have any other questions, but I think I've addressed everything with respect to the Open Meetings Act also.
Great. Appreciate it very much. Now, I'll take one or two questions of the gentleman, but we're not going to stay on this long.
Yes, sir.
The board and the association has to go by section 209 of the state statutes? That's the property owner's code?
Yes, that is 209, Texas Property Code 209.
Okay. Do they have to, what do they have to do according to 209.006?
I'll tell you right now. Do you know what that section pertains to?
Pertains, the first sentence is about restricting the members' entry into the common area.
It jumps from 209.009 to 209.014, my records here. So I can't give you an answer on that. Unless I take a look
In
at
other
it,
words,
or
before
unless
they
you have
restrict it. But the gist of it is, before they restrict the members' access into the common area, they have to send him a registered letter, return request, informing him of his violation that he can no longer enter the common area.
That's probably correct, sir, and it goes in line with any action that's to take place against an individual member, or a right that's going to be restricted from that individual member. They need to be provided with notice and an opportunity to defend themselves at a board meeting.
Okay, the upcoming hunt, they're going to restrict the majority of the members from the common area. How do they get around that?
I'm sorry.
Talking about coming hunting, and they're restricting the majority of the members from the common area. They're letting a select group unlimited access to the common area, and they're barring it for all others.
I would have to, without knowing more about it, I would have to visit with the association and with the director just to see what type of action took place, or if it has taken place.
I think I can respond. Looking at Article 4, Board of Directors powers, coming down 6, 7N. At its discretion from time to time to permit and for the safety, physical health, welfare, and preservation of landscape and improvements on the real property, to deny access to the real property or any portion thereof, and to make reasonable charges for any entry on or use of the club grounds. I would argue strongly that we have a vested interest in this hunting because we need to cull the herd, because we need to manage them for public health reasons, for preventing an anthrax outbreak, because it enriches the coffers of the whole, and I believe that we have every power right there to do so intermittently as needed.
To restrict all members, not a select group.
We can restrict members and we can allow others on. Yes, I believe it is the case. Yes, and non-members. Because they are doing us a service by culling that herd and paying us to do it instead of us having to pay to have the animals removed and culled. It will enrich our coffers, and it is a very small amount of time each year to be denied access to those grounds.
It's 6 months.
Oh, no, sir. No, sir. It's matters of days and dates, sir.
Another hand,
I have,
Yes.
you know, they say there's no such thing as a stupid question. This may be it. Where am I going to find property code, whatever, on
209.
the internet? I go on the internet, state of Texas. What do I do? Tell me how to find it.
The easiest thing, if you go to Google, you can just put Texas Property Code, Chapter 209, and it should come up.
Tell me again. Property code.
Texas
Uh-huh.
Property Code, Chapter 209.
And it should come up.
Yes, ma'am.
And if it doesn't, I can call you and ask you.
Yes, ma'am.
Mary,
You
And you're not going to charge me.
Mary, I found
Well,
it.
I would charge, the
I
easiest
found
thing
it.
would be to call the office, and,
I'm
you
being
know,
silly. I'm being silly.
we provided a copy here, so you can make a request under the open
No, I
meetings.
just don't. I just want
Under
to
the
make
open
sure I
records.
can find it when I get home.
I can help you find it. I found it once myself.
Okay.
Can I take that question?
Yes. Could this be the last question,
Does
please?
does homeowners association rules and regulations supersede Texas law? Is Texas law supersede homeowners association rules and regulations?
You mean our own bylaws and rules and regulations?
Yes.
Okay, to the extent that they differ from this act, the act is going to prevail. You first look at the act, okay? But if there's nothing that's contrary to what the act is providing, you keep following your bylaws and your procedures and your policies that are implemented. Like, for example, what she just read, if it's specific in nature and nowhere in here does it address that particular issue, then the bylaws and the policies and the procedures of the association would prevail.
So in other words, wherever we had written that only members in good standing could vote, and that is now, as I understand the property code, that no longer applies, we have to go through and strike that because it is superseded by the code, as I recall.
I need you as a law clerk at my office. Yes, I actually had stars here, and I finished my presentation, and I failed to address that. There's two big changes by the act, where before you had that sort of policy in place, the code, the act, now specifies that a person that would otherwise be disqualified from voting under the bylaws or the procedures in place, that now is void. So you need to allow that member to vote. The same thing, to run for board membership, a provision in one of those instruments, the policy, a covenant, the deed, that would restrict a property owner's right to run for a position of the board is now void. So even if you find yourself with someone that, for example, their views are not up to par, they would still be able to run. Now, if a person has been convicted of a felony or a crime involving moral turpitude that is on the board, they must be immediately released from that position.
So in effect, this discussion and consideration of appointment of a nominating committee we've got in our packet for today is actually void. We don't need to have a nominating committee because anybody that wants to run for the board, we have to allow them to, don't we?
That isn't what he just said. Would you clarify that, please?
We must allow them an opportunity to vote or to run, but I understood that you go through a selection process and you do nominations, so you're still entitled to do that.
Exactly.
But people can self-nominate, yes.
Okay.
They can self-nominate, and if they meet the criteria, yes.
Right.
The nominating committee can't deny them
Okay.
a position on the ballot, as I
If they
understand.
meet the criteria.
Right, right.
As long as they're met.
The nominating committee remains helpful because they help us find people who are willing to serve.
You got one last hand in the back up there.
Yeah, this conviction of a felony or a crime of moral turpitude, it's effective immediately. So as soon as you get a governmental record to reflect that that person, him or her, has been convicted of a felony or a crime involving moral turpitude, it's immediate. He must be removed from office, and he or she can no longer take action. That's all I have, gentlemen, ladies.
One last hand up there.
Yes, ma'am.
Very, very quickly, is there a statute of limitations? For example, if there's a former member that has not contacted nor paid any association dues, is there a period of time after which they can be dropped from the rolls and they don't have to be sent a ballot? Or is this for life? If somebody hasn't paid in 20 years, are they still entitled to vote?
Well, my advice would be to go through the foreclosure proceedings that are available to the association so that you can eliminate that issue. Because so long as that person is still there, the act does not provide that it's only good for 5 years or 10 or 15. That person, in my initial interpretation of the law, would be eligible to vote or to even run as a member. And there's some serious issues, because then what about all of you who have been compliant and who have been doing everything that is being asked of you? So I think that's where the board needs to consider, okay, everyone that's there, we need to move forward, initiate foreclosure proceedings so that we can address that issue.
Okay. Thank you very much.
Thank you. Thank
Let's see. Yes, sir?
I'm available by phone. That's another thing. If for some reason one of these issues, there's a legal issue that comes up, you can actually, while you're holding the meeting, contact legal counsel on the phone. Put them on speaker, or if it's an executive session, you can retire into executive session and place that call to your legal counsel. Okay? Thank you all.
Thank you.
Thank you.
Thank you. Thank you.
Next item on the agenda is the presentation of the financial statement.
Who is he? Eddie Morales. He said his name, Eddie Morales. Right? Eddie Morales, right? He said his name.
Yeah, you got it out there. Excuse me.
Mr. President, can I make my motion regarding the financial statement of July?
Sure.
Can you allow that?
Go ahead.
Okay. I move to rescind the motion to file the July financial statement for audit on the grounds that I now understand that the auditor expects to receive only statements that we believe to be accurate. And as I recall, we knew that it had some flaws in it, and I voted to put it forward to audit, and I now realize that vote was in error. So I think properly we should have postponed to a certain time when the statement was corrected to our best of our corporate knowledge, and then have moved to file it for audit. Can I get a second on that from anyone?
I would second that.
Thank you. Discussion?
Any other discussion?
No, I agree with her.
I know that. I got the second. All in favor of that particular? Motion passes. Now let's move on to this month's presentation of the financial statement. Do I have a motion on the financial statement, please?
Mr. President, can I ask for clarification
Of what?
from D.O. Stevens as to whether there are also still remaining problems with this statement.
Can we have a motion first, and then we'll discuss that?
Ooh, sorry, excuse me, breach of parliamentary procedure. Okay,
We have to make a motion.
I make a motion that we consider the presentation of the financial statement.
Do I have a second? I have a second. Discussion? Now you may.
All right. I will ask if there are still some problems with the numbers in this financial statement that need to be reconciled before we can put it forward to audit.
No, the new copy I gave you, the only reason we gave you a new copy today is because the old copy that was ran on Monday, I thought that there was a $3,200 error in the suspended account, and what that was is I sold a lot in Unit 7, and they didn't put it in the right line item, so it came up as a suspended account. So we fixed that. You got the new copies today, and it's in a suspended account. It's a
Any further questions? Rhoda? Which item did she correct there?
It's on your, it's on page, either page 5 or page 6. I don't have the error copy.
Here's, let's see, right here. 6.
Page 5, where it says suspense account,
$3,060.
on your original statement, it says $3,200.
Yeah.
That's the correction.
Okay.
It's on page 5 at the very top underneath Fort Clark Springs Association revenue.
Right. See it. Any further questions?
What is a suspense account?
That's whenever something is not appropriated right, it comes up as a red flag. So normally that line item's not there under revenue. And I caught it when I was trying to put in the August information in my new spreadsheet.
Any further questions? All in favor of passing it? Motion passes. Approval of transfer of funds.
I move that we approve the transfer of funds.
Do I have a second?
I'll second.
Any discussion? All in favor? Motion passes. All right, we'll have the report of the Director of Operations, please.
Try to keep this short since we're kind of running behind on time. I hope that you guys all enjoyed that informative speech from our lawyer. As we make our way forward, I continue to keep the best interest of the membership, the board, the employees, and the growth of this facility. And the more information that I can give you, the better off we're going to be, so we can come to an agreement that we can actually make those steps forward. There's been, in the past month, some misconceptions. I urge everybody, if you've got concerns, and I'll keep hammering this in as long as it keeps coming up on my plate. I can't change the past. The board can't change the past. We can only work towards the future to make this place right and get it on the place it needs, in the place it needs to be to grow. So with that being said, I have changed the hours at the swimming pool. So when it comes dark time, we are closing the gates at the swimming part. This has been a very big hot topic, as anything is when you change things. And part of that is because it's a huge liability whenever my security cannot see in the darks of the trees what's going on, or in the swimming pool, or if somebody were to happen to fall in and get hurt or drown, God forbid, this association cannot handle a liability like that at this point in time until we can have the resources to fix the problems. We've had a high increase in criminal activity down at the swim park this year. Even had an altercation as early as Tuesday of this week. So that's the big reason why I'm closing at dark time, because it is unsafe at this time. You have drug dealing going on, you have alcohol, underage alcohol drinking, you've got potential fights happening, one that we calmed down on Tuesday. So I hope that everybody understands why we're doing this, or why that I think that we should be doing this. As far as rental properties that we have, this is another big misconception that was out there. Dickman Hall is no longer on the register for rental. Service Club is still available. Post Theater, if the dates are available, it's rentable. And not Shafter Hall, which one is it? Saber Room is also available. Those 3 buildings, you can have a party up until midnight. Anything with 50 people or more, you're having an event, you gotta have event insurance. It's a nominal fee. Again, it's another way of protecting the fort as a whole. So if things go wrong and something catastrophic happens, we have another layer of protection before it hits us. I hope that you guys can understand these things. I don't do things without having a reason for it. And ultimately, I'm putting the best intentions for this place and for you guys. So I hope that you understand and hope that you can back some of these decisions right now. And we have a lot of areas that are broken. I said this before. And it's going to take time to fix it. And it's going to be uncomfortable, a change for a minute. But we'll move forward and make this place so we can invite more people in to come and buy, to come be members, and we can see this forward movement and forward growth. Any questions on that?
Where do we get the event insurance?
I'm working up something with our insurance company now so that you can just call him, he'll print you out something, and you can do it all online and pay your fee. Let's see. And to back up from last month's issue is the whole nepotism thing. I just want to squash this and get it out there. It was not out there last month, the information. From day one when I was hired on and I stepped foot in this office, I had Janelle and Camille write up an agreement that Camille De La Cruz reports to Janelle Hobbs, not me. So I want to get that one squashed. So anything that has to do with her is done through Janelle, and that's been happening since the first week I've been here. So moving forward from that. As far as moving forward with the hunt, hopefully in a second we'll approve to have these dates. And I want everyone to know, non-hunters, hunters, birders, the whole gamut, I'm trying to keep everybody safe and make it fair for all parties involved. And whenever we present and approve or disapprove the hunting dates, I want you guys to understand that I ride horses on the trails, so I'm giving up weekends on not riding back on the bag. But it's a sacrifice I think we must make. And with that, be rest assured that all hunters coming in will have to sign waivers and everything will be documented correctly as it should be. And then there's not going to be some mass slaughtering. It's all going to be governed quite well. I think that I have a good staff in play, a good volunteer group in play, that we're going to really restrict what is happening and not happening. Moving forward to just the general report. Motel is full this weekend. Revenue for the month of August was $26,094, with a year-to-date total about $13,989 above this time last year. I'll save RV Park for Shirley. Golf course, we continue to still make strides in the changes with a new pro shop manager It's a slow process. I'm hoping in the near future we can actually open up the snack bar and it can be ran underneath the golf shop pro shop, so that we can actually have revenue coming in instead of deficit. You were here on Wednesday's meeting, you would have gotten the full gamut on that one. The pool year-to-date revenue for the pool through August was $15,261. Membership stats, 6 items sold during August, was 70 sold year-to-date. And coupons, I know a lot of you, this is another big thing that came up in the past couple weeks. When we mailed our coupons and people who are on auto pay, for some reason we sent you coupons anyway, which defeated the whole purpose of being on auto pay to save on paper. It did slip through the cracks this time. I apologize. We're going to work diligently to get that fixed for next year. Collections, we have collected $10,232 in August, with a year-to-date total collections of $64,863. And again, I want to keep throwing this out there until it comes to fruition. Maintenance. I really, really, really want the general membership to start kind of putting in your head that we're going to move towards Monday all pickup trash. And then hopefully evolve into twice a year brush pickup, so that we're trimming trees appropriately like the rest of the United States does. And with that being said, just kind of start gearing yourself with Monday all trash pickup. Would you like to see all your trash gone on Monday and not have to look at it until Thursday? Plus, it's going to help us work more efficiently with maintenance, and we can actually get to other business that we should be doing. So kind of keep that in your minds. Other than that, that's all I have right now. Yes?
If we have twice a year brush pickup, what do we do if we have brush during the rest of the year? Fill out a work order, or?
Collis will come pick it up for a fee. It's going to take some time before we get to the twice a year.
No, I was just.
But after that, it would be a fee. Like if you have a washing machine that's not picked up on Monday, then we're going to charge you to come pick it up. I'm trying to reduce our $40,000 fuel bill. If we're driving around one time, we're done.
Exactly.
So we leave a machine out on Monday, they'll pick it up on Monday?
Well, and then we're not there yet, but yes, that would be in theory. Most work would be done over a weekend, so if you got trash, you put it out there. If you've got an old washer, dishwasher, it gets put out there. And we would drive in a convoy, and we'd pick all that stuff up, break down the boxes. A lot of people don't break their boxes down, which takes time from our maintenance to break down people's boxes. So, yes, I would foresee a whole change, but for the better. Yes, sir.
What is styrofoam considered? Is it considered trash, garbage?
It would be garbage.
Do
you have a lot of styrofoam?
When you get a machine, a washing machine
Sure.
or something, it's got all those big blocks of styrofoam in it.
Well, I would hope that you would be considerate and take those things out, put it in a trash bag, and break down that huge box or cardboard.
Well, I know, but what about the styrofoam blocks that are in there?
It's going to go in a trash bag.
So it's going in garbage.
Yes, sir.
Good.
Yes, sir.
Okay, we'll have our committee reports. Architectural. I guess there's nobody here. Recreation.
Yes, we had the ice cream social, the Saturday was wonderful, really good. Potluck this Monday night at the service bar at 6 o'clock. We will have a speaker, a lady from the assisted living facility in Del Rio, the new place, is going to come and address the group. So we look forward to seeing you Monday at 6.
Thank you. RV.
We had a really good month in August. We showed, even with some extra expenses, we had a large expense for batteries for the golf cart. That cost us $800, and we weren't expecting that, but it had to be done. And then our electric bill was extremely high because of the air conditioners. We had an electric bill of $6,814, but even with those expenses, we showed a profit for the month of August of $11,490, which I thought was very good. And they tell me that they're going to be there until December, most of them. We have some that are laid off every week and others come in, but the majority of them will be there until December, so that's going to be very good for the fort. This year to date through August, our profit for the RV park has been $110 and $110,309 compared to $50,963 last year. So I think that has really been good for the RV park and for the fort. And the rain is keeping the dust down for the last few days, and that's good, and we'll have some more green grass. And we just are happy campers out there. Thank you very much.
Thank you. Dolph?
Okay, we have a new pro shop manager, and so to accommodate him somewhat, the golf committee meetings are now going to be on the second Wednesday of every month at 1 o'clock in the afternoon. So
Who is it?
it'll get us away from Monday when the golf course is closed and can't get in.
Who is the dog?
The new pro shop manager, his name is Chris Coons.
Chris?
Chris Coons. He is a young man, family, in fact, just expecting his third child, haven't heard she's had it yet. Very impressive young man. He is taking the bull by the horn, so to speak, and he has cleaned up the area around the tennis courts, not waiting for Fort Park maintenance to do it for him. He's been out there weed eatering. He's cleaned up the pro shop. He's trying to make it look more professional. Lots and lots of good ideas to make it look more professional that aren't going to cost a lot of money that volunteers can help with. He's got some wonderful fundraising ideas, so we're really, really excited about the choice that the board made as far as hiring this gentleman. Besides, he's kind of but he's a look, don't touch, he's good. And we're hoping that hole number 10 will be open in about 2 weeks. They're checking it, they've mowed it several times now, but we have to make sure that that sod is totally seated in the ground. It's not floating anywhere, and that it's actually establishing a good root system. It's being watered twice a day, as I understand it, and the rains have been nothing but help the golf course and for it. So that's it.
Thank you. Preservation. Okay.
Well, we had our meeting on Thursday. Usually it's on Wednesday, but the board had a meeting that day, so we met Thursday evening. Very informative evening. We also found that we have a little bit of a reprieve on when our time limit is on getting the buildings repaired, as the historical, Kenny County Historical is requested. So therefore we'll be able to find more bids for the jobs in the future. Take our little time a little bit, not hurry up to do. That's
Thank you. Community Council?
Community Council has begun their preparations for Fort Clark Days 2013. I did, as Robbie read, the presentation asking for the use of the 2 billboards, the big ones at either end of the fort. They're, as present, they're dated and they're faded. And the idea would be to use those with another covering from December through March to promote Fort Clark Days, to draw attention to the fort, to try to get more people aware. We would advertise our lead sponsors, our big sponsors this year. We've made a complete overhaul of fundraising efforts. We are confident that it's going to produce more money than we've ever been able to do. We're trying to make it a vehicle to promote the fort as well as provide a fun 2 days for everybody here. So we would appreciate any help that the board may choose to give us in that effort. As you know, the money we make comes right back into it's used for the benefit of this place.
Do you want to do recycling, or do you want me to do it?
I read that, and then we didn't make a motion or approve
No, we
them
didn't.
using the signs, or?
Didn't have it for an agenda.
We did
I
not,
didn't-
it wasn't on the agenda, that's
I
why I
didn't
didn't
have
do
anything to put on
that.
the agenda.
Yeah.
Can we get it, I guess, on the agenda for next month, or?
I don't think we have to. We can do it through the office if you want to. It's just the billboard.
However you want.
Yeah, why do
I would
we-
suggest it was a good idea, that's why.
It is a good idea. I think we can do it through the office, make a decision.
However you want to do it, the board's not going to vote on it.
one of those ones that you mentioned, that you didn't have to have a meeting. Recycling, as I said, you want to do it because you got information that she gave you, and this is about what we have now and what has happened with the last time. I'll just give you just a brief overview. Last time we sent out a load, we received the negative back because the bottom has dropped out of just about everything that's going out. What most of the places that we work with, we have a half a load with, is ours, are now waiting until we have a whole full load, and they're still not making any money worth a dime, but that's inhibits us from being able to send out our half a load. Right now, we are loaded to the gills for a load to go out, which hampers our area to go further down the road and have another half of a load, you know what I mean? It really is becoming a problem. But she can tell you what was said about the costs and how they're going forward.
Our coordinator at CCRA told me was if you can hold the load, do it. We're hopeful that prices will come back up in October. They usually do start to go up in the fall and through the winter, and they lower in the summer. However, she said that there are organizations with much larger volume than ours who are shipping baled paper and having to pay for it because the paper market, they get $10 a ton. If we ship 4 tons of paper, that's $40. It costs us $240 to ship a half a load. So we're going to try to hang on, and I know it's going to get crowded down there, and we beg everybody's indulgence, bear with us. If we can get enough plastic and aluminum together, we can ship that as a half a load. Those prices are, they're not great, but they're not, they're not going to cost us money. We're trying to manage to keep ourselves so that the recycling is a net gain in terms of landfill expense. Hopefully by the middle of the winter, we'll be back to getting the, was it Janelle, what, $160, $70 checks every time we shipped.
That's about what it is, yes ma'am.
So we're gonna kind of be bursting at the seams, but bear with us, and we'll keep on collecting recyclables, and we will try to cherry pick what we send for the time being.
Thank you. Discussion, consideration on hunting dates.
I move that we have a discussion and consider the hunting dates.
I second.
May we have a discussion?
Yeah. So what she's passing out is the breakdown of how we would be doing this. It'd be every other weekend from October until February, the hunt on the fort, and on the other weekends it'd be the hunt in the 400 acres.
I don't know. This is like back and forth.
So last year we had a total of 28 days that we hunted, and with hunting every other weekend, so we're not hunting every weekend here on the fort, we're hunting on the 400 acres so then we can open up the trails to the birders and the hikers and the runners and so forth. And so we'd be having a total of 54 total hunting days. Still only 24 on the fort, and at least 30 days on the 400 acres.
When you say the 400 acres, could you tell me where that is? I don't know.
It's, you know where the landfill is at?
No, but I'll
Seminole
go
Road,
sometime soon.
Seminole Road?
Yeah.
So when you head out Seminole Road, take a left, on the right-hand side is where the gun club is at.
Oh, okay.
The 4-H has a land lease on our 400 acres over there. And then this is actually, I have where our blinds would go. This is the 400 acres.
Oh, okay.
This is the gun club. There's Seminole Road right here. There's the gun club. That's 4-H. That's our burn pit. So wherever you see red is where we'd have a blind. this map is where we're gonna have blinds. Anything in red's a bow blind, and the blacks are the blinds. Red is bow blinds, and the other in black is the regular blinds.
Could you show or tell us where the blinds are gonna be, or?
We will in the future. This depends on what's gonna be discussed here. And there's two parts to sharing that information, because I don't want vandalism at our blinds, nor do I want my hunters harassed. So this will be given to my security, my volunteers, people that help police illegal hunting. As far as the general membership, probably not. Everything will be marked off very well. That keeps volunteers, or not volunteers, it keeps the general membership who's not a hunter out of the trails and safe. But I know there's been lots of things happened over the past few years. There have been malicious acts on deer blinds, malicious acts on my hunters, the visitors coming in to hunt, and I need to protect them as well. But everything will be marked off appropriately to keep general non-hunters safe.
So I assume you're not gonna, what the attorney said about state statutes preceding operations on the fort, state statutes have present, right? Precedent?
No, the board approval has the precedent.
I thought he said state statutes supersede. Didn't he say that?
What are you referring to, sir?
He said, didn't he say state statutes supersede past procedures?
When they're in conflict, sir.
Okay.
But if there is no state statute that impinges and contradicts our declaratory instruments and our bylaws apply. Our declaratory instruments apply, sir.
He said that. State statute 209.006 addresses that situation.
I will review it, sir, but I believe you're mistaken.
Okay.
And I believe I appropriately explained where our authority comes from in our declaratory instruments.
It isn't about the authority, it's about the notification. That's what it says.
There'll be notification on the marquee when we're hunting on the fort. There will absolutely be posting. Not only that, there will be signs at the blocked off entrances. We are not blocking off the entrance to the Red Bridge. You can just not go past the Red Bridge. And those trails will be marked off. But you can still, people who like to go to the Red Bridge, stay on this side of the Red Bridge, you will be safe. And then every other weekend, you will be able to go onto the trails on the fort and go, you have all week. These hunters are only doing it on the weekends, every other weekend on the fort. So again, I'm trying to make this as fair as possible for all parties involved. The last thing I want is somebody to get hurt, somebody not shooting where they're supposed to be shooting, and then those are the things that we're gonna have to combat.
I understand all that. This is not about restricting from the closed area, it's about notification.
Yep,
And there will be notification on the marquee.
It
and-
says what you have to do.
and the website.
And the website will be notified there as well.
It's just like what he said about the certified mail. It's exactly
No,
the
you're
same
mis-
thing.
You're
You're
confusing
mistaken.
things. You're confusing things. Let's not go there,
But
please.
he also said he would check on that property code 206, but he did not have it with him.
Right. Can we go forward on this, please?
Yes, please.
Do we have concerning this?
I move that we accept the plans for the hunt, the dates, as presented.
And the areas?
Yes, and the areas.
I would second that.
Any more discussion? All those in favor? Motion passes. Now that we have gone this far and past this particular thing, something like this will be made public so that everybody can have a look at it. Jody will make sure that happens. All right? With you? Yeah, post it someplace in the building. All right. Appointment of the nominating commission, committee. Commission probably be that. Would you read that, please, this motion?
In accordance with the bylaws of the regular September board meeting, the board shall, is that what you're talking about there? Yeah, well,
No,
yeah, we're not nominating anybody.
no, we're on the other one. Appointment of the nominating committee. Page 12, is it right?
Well, yeah, I know, but who are you going to nominate?
You can make the motion and then we'll give you the names. Right, yeah.
Okay, I move that the following members be appointed to the nominating committee, so. And what members are we talking about?
John Carlson.
Okay, I move that John Carlson, Russell Knoll, Jeff Janka, Glenn White,
And Pat Melanson.
Pat Melanson be appointed to the nominating committee.
Do I have a second?
I'll second.
Discussion? That's when you read the rest of it.
I assume everyone on the list has said they would serve?
Yes. I tracked them all down myself.
Okay. And how many wrists did you rub?
Quite a few.
Want me to read the discussion on that?
Yes.
In accordance with the bylaws, the regular September board meeting, the board shall appoint a committee of 5 members to serve on the nominating committee. The purpose of the committee is to nominate 2 candidates for each position to be filled on the board at the annual membership meeting to be held the following March. There will be 3 positions to be filled in March of 2013, those being 2 3 terms, Slade and Young, and 1 for a 2-year term, Keeley Peak. Each of these individuals are eligible to serve another term. The duties of the committee members are to select, first of all, to select 2 candidates for each position to be filled. Committee members may solicit applications from persons thought to be qualified or interested, or interested members may submit applications to the committee on their own initiative. The committee members must certify that the nominees meet qualifications needed to serve on the board of directors. They need to present names to the board of directors at their December board meeting and certify that petition signers and candidates by petition meet qualifications at the time of filing of the petition.
All right. Any further discussion on this?
Could you tell us those names again?
Yes. I'll read the names again. You got John Carlson, Russell Knoll, Jeff Janka, Glenn White, and Pat Melanson. All in favor? Motion passes. Would you read this one? That's discussion on the consideration of appointment of election judge.
I move that the firm of Glenn, Graff, and Bowers of Del Rio be appointed as election auditors for the 2013,
Yes, go ahead.
2013 election at a cost not to exceed $4,000.
I'll second that motion.
Discussion? You want to lead this discussion?
In accordance with the bylaws of the annual elections, tabulation and certification of the vote is to be handled by an impartial auditing firm designated by the Board of Directors. The auditing firm will utilize the certified list of eligible voters prepared by the Certification Committee. The results, as certified by the auditor, shall be presented in person at the annual membership meeting by a representative of the auditing firm. Through the years, we have solicited quotes from other CPA firms in Del Rio and Uvalde area, but due to our election falling in the middle of their busy tax season and their lack of personnel, most have declined to quote. We have also solicited quotes from companies in San Antonio, but their prices have tended to be higher. The firm of Glenn, Graff, and Bowers has performed the tabulation and certification for the annual elections since 2003. Last year's cost was $3,650. The cost was greater than it had been in previous years due to changes in the state law, Texas Property Code, which requires that all memberships receive a ballot, whether or not they are current on their accounts, their assessments, etc., with the association. In the past, only those members in good standing were eligible to receive a ballot.
Any further discussion?
So it's anticipated that last year's cost will be substantially different than this year's.
No. All in favor? Motion passes. Let's see. Discussion, consideration, appointment of an election judge. Keely, would you read that, please?
Yes. An election judge is optional in accordance with the bylaws of the association. The secretary of the association shall be the chairman of the certification committee, and it shall consist of the secretary of the association, which in our case is Roby, the chairman of the nominating committee, to be determined, I presume, the election judge if one is appointed, and then one representative appointed by each candidate for the board of directors. The certification committee shall review all items presented by the director of operations and prepare a certified list of memberships and mailing letters, labels for each membership which is eligible to vote. The certified list must be completed by January 31st. One individual should be responsible for the election process as follows: setting up an organizational meeting for the nominating committee, providing data sheets for individuals interested in serving on the board, and in turn submitting these to the nominating committee. Contacting the election auditor to advise the number of envelopes they need to provide for our mail out of the actual ballots. Preparation of calendar of various important dates as relate to the election process, preparation/provision of certified list of memberships to provide to the election auditor, preparation of mailing labels for each membership, draft of candidate resume and ballot for board approval at the January board meeting, printing and preparation of the ballots, letters to board candidates as to what information they should provide to go along with the ballot, contact and coordination with candidate representatives relating to mail out of ballots, oversee ballot stuffing and mail out to members. Nancy Frerick has worked closely with each board secretary in the election process since 1988. Serving as election judge since 1992. She is probably more familiar with the complete election process from certification through mail out of ballots than anyone.
That's just a thought.
Yeah, we had those, last year, we had to have 2 representatives, then we got a balance, it says 1 here now.
Yeah, that's what it says. One.
Is that a mistake, or is that one?
I didn't put it together.
Previously, there was 2 representatives by each board candidate to help.
You only had 1 this year. Is there a
It says
reason?
1 now, is that a problem or not, or?
No, I think it's different steps in the process, as I recall. The 2 are required for the actual stuffing of the ballot, but I think only 1 is required to be in this process here. I think it's just a difference in when 2 are required, as I recall. I did kind of hang up on that myself, and I went to look, and I said, oh, I think I understand now.
Answer the question.
Are y'all discussing or whispering?
Well,
No, we were discussing the number of 1 versus 2 that was last year.
There was-
It says 1 on our paper. We were just wondering if that
we
was a
were just
typo.
clarifying a question about what I read at this point. No motion has been made yet.
Y'all are whispering.
I know. In the background.
Open it. Why whisper?
At this time, I'd like to ask if, Betty, would you consider that?
I mean, yeah, as far as what I have to go through, like what you just.
All right,
raised.
I'd like to appoint Betty Wright as the election judge. If that's all right with everybody?
And could I just, first I'll second, and then we can, okay, I'll second, and then I'll ask for you to just clarify why we're making the change, or considering the change.
I'm considering the change because I know Nancy's on the edge of retiring, okay? And this just takes one more, burden off of her that she doesn't have to consider this year. And we have to look towards changing anyways, so somewheres along the line, we have to implement a change. Is that satisfied?
Yes, sir.
Okay.
And if you were concerned, that was just what we were trying to understand up here, is that we would be considering the nomination of someone other than Nancy. So it was just disseminating that information so we can move forward.
Any other discussion? All in favor? Motion passes. All right, next item here is the approval of 15. Yeah, I know, but it isn't on here. It's here, but isn't here. That's, sorry, the hang-up was what you got in here, the property tax is not on here. The budget is. So that's the next thing, was the approval of the budget.
It says number 15, discussion consideration of levy of common property tax.
Mm-hmm.
It is on the agenda.
I'm done.
Number
Where is it?
15.
I know it's right here. I'm looking over here.
It is number 15.
15 is, well, I got a different paper.
What's the one in your, yeah,
How did I get 2 different papers?
that might have
Everything's
been
been right
the
on that.
previous
Yeah,
agenda.
okay. It says October. All right.
I move that we have a discussion and consideration for the levy of the common property tax.
I would second that.
Any discussion?
Yes. Mr. President, I think the first thing we need to address is where our authority comes from. And I am directly addressing a question raised by Member Hahn about the difference between the club grounds and the improvements and buildings on those grounds. And I would like to understand, I want to understand, okay? I've heard his argument, or I've read his argument. I want to understand the flip side or the counterpoint, which is where our authority comes to assess common property taxes on the improvements, the buildings themselves. I'd like to go on record as saying I cheerfully and gleefully want to pay property taxes on all the buildings held in common because I have a stake in them. I have a stake in seeing them preserved. I take great delight in them, and I in no way am questioning my will to contribute that money in that direction. I just want to do due diligence to a question that a member has raised. So that is my query, please.
Have anything you want to offer on that?
Well, based on the new budget, that was a total projection based on last year. We haven't received the property taxes yet, so I can't give you a breakdown. And then really analyze it as what was presented by Mr. Hahn. So I don't really have an honest answer for you until I see and investigate it.
I think the question is, we're supposed to pay property, the membership has the duty to pay taxes on the property, but not the improvements made thereon. The fort itself somehow has to raise that money through other means other than this assessment to pay taxes on the actual improvements. Is that not correct? Or?
Well, that's Member Hahn's argument. You know, it's going to come from us. It's going to come from us one way or the other, if we're honest about it. It either comes out of a common property tax where we help pay those assessments, or it comes out of the assessments we're already paying. If we do not chip in and help pay that common property tax, then we're just going to beggar ourselves in another sphere. I think that's pretty much the bottom line. And as I see it, it's a way, you know, the argument against it is a way to say, you know, to force it out of what is already being raised in assessments. But I did want to find in our declaratory instruments the basis for our having historically assessed on the structures. I don't think it came out of nowhere. I think it must have been derived from something here that, you know, could be looked at and say, well, I think this gives us the authority. And I
understand what you're saying. I've done the same thing that you're doing. I went through that, and I could not establish anything other than what was written on that email.
May I say something, Mr. President?
Sure, please.
I guess as most of y'all know, I've been here for a long time.
on the common property tax, that was something that was being assessed at the time I came to work here. It's been done no differently now than it was then. To say it was right, I don't know. I'm very disappointed and saddened that the individual that sent correspondence to the board did not have the courtesy to come in and say something about this some years ago when he first discovered it or whatever. Maybe he only just discovered it, I don't know. But it gets a little bit tiring for, as he referred to, career employees. And I guess there's only two up here in the office that could be considered career employees, if you will. It's very sad and disturbing. The only answer I have for that, sir, is that that's the way it was being done when I came to work here in 1981. Up until 1991, the common property tax was levied among the entire membership. North American towns at that time, the association paid the entire tax bill. But during those years, North American towns still had a number of memberships that were unsold. They were charged their 1/8,000th, if you will, their pro rata share for each of those unsold memberships, which North American towns paid. The rest of it was divided by the memberships that we had on our rolls. In 1991, the board at that time was going to go up on assessments. They decided that the assessment increase would maybe be more palatable if they didn't levy the common property tax among the members. That was done. So from 1991 until 2001, I believe, if memory serves me correctly, there was no common property tax levied. The association just absorbed the whole thing. And in 2001, it commenced again. And it's just been done the same way. To say it's been done incorrectly, perhaps. It does make me feel very bad to be, while names were not used, it's obvious who the individual was speaking of.
Yeah, and it pains me too to read it.
I understand.
Believe me. I think I found,
Question. So, we've been paying, we've levied the common property tax for 11 years now to membership, right? Why has it not been put into the budget and budgeted by the association to pay the common taxes? And if it causes an increase in assessment, then increase assessments, we have to pay it anyway.
It's going to come
Why
from
not
one
spread
pool
it out
or the
over a
other.
year rather than just hit us with a one-time fee? I mean, why are we doing this?
Because it
I
says...
understand. Also, you got to understand on the fact that we just got into a new budget setup that we did not have before, you know, and it takes a while to tweak it to get it to work the way you want it to work. And yes, you're right, the way you said it. It should be working that way. But it isn't this year because we're still, you know, back the way we were running it from the year before.
It's a consensus that it needs to be done.
Right. So
Right,
anyway,
my law states you can only raise rate by a certain dollar amount, so you couldn't put it in a regular raise to absorb it by your bylaws.
understand.
Um,
So, did you find something?
Well, this again is Article 4, powers of the Board of Directors, 7, and this would be B. To maintain the club grounds and to repair and restore the facilities thereon, including utilities, landscaping, and other services benefiting such property. Maybe that was, you know, extended to the, you know, the need to, or the marriage of not only the ground, but the improvement that's on it.
Right. Well, looking at this the way it is, we can't deny the fact that we're going to get a nice big tax bill coming in. And this has been coming in every year. This doesn't go away. And all this is just an amount of money that is mentioned, as was in the motion as it was read, to cover those taxes. like we did in the previous years. How it's tuned out and how it's displayed of where the money is being spent on, whether it's on the building, on the land, or all that, that comes into another area. It doesn't come into here right now because we still have to raise this money. And so this is the vehicle to raise the money to pay the taxes. Has anybody else got an opinion on this?
What did you
Board
say?
members,
How
please.
has it
Board
been paid
members.
for the last
Discussion stage.
5 years?
It's been, the only thing that is backed out of it is the lots that are owned by the association, because those are not considered part of club grounds.
Right.
It's always been considered that the buildings were considered club grounds. So I think that's where, you know, like I said, perhaps Mr. Hahn's correct. You know.
Oh, no, how has that been paid in those last few years?
Pardon me?
How has it been paid these last few years?
Okay, when we get the total tax bill, the only thing that we back out of it, the mud tax is paid from the impound fund. The remainder is paid out of the general fund, but it's prorated among the memberships. The only thing that is backed out of that figure is the taxes on the individual lots that the association owns, because they're not considered a part of club grounds. They're in platted lots.
Any more discussion?
I would say that we probably ought to look at it to have it included in next year's budget maybe, or separate it out how it ought to be versus how it is. I don't know, have to go over the bylaws and see how, somewhere it does say in there, I seem to remember about we had the right to pay taxes on the ground. They had the right, we have the right to assess members that fee. But there's several other things in our bylaws that are antiquated because of the homeowners law that we've got in there yet, aren't there, that we need to change as well? We probably need to go over several of those things in the near future and make changes on those all. I think we have no other choice but to pass it this year because of the time frame we're in, and we've got to pay it whether it comes out of the left pocket or the right pocket.
Exactly.
It's got to be paid by the members of the board, no matter what you call it.
Any further discussion? All in favor? Motion passes. To answer your question and your hand being up there's a rule established here that the hands do not come up in this particular part of the session. We have already gone over this before. So I'm not ignoring you. You have a 15-minute discussion later. Anybody wants to put their name on it, that's fine.
Janelle, I'm sorry, could you read the motion that we made?
The motion,
Yeah.
the motion that we had, Mr. Slade moved to discuss the levy of the common property tax. There was a second and that carried, and then we followed into discussion.
Okay.
If a motion was made to approve it, I missed it.
No, I think, Mr. President, I think we do need to go back and make a second motion to.
I thought you did that.
No, sir. No, sir. It was to discuss.
Just to discuss.
It was to
Okay.
discuss. So we need the second motion to approve.
Okay, thank you
Okay.
for your diligence. Would somebody give me a second on this?
I'll second it.
But who made the motion?
What? You have made a motion.
Oh, nobody made the motion.
Yes.
Okay. I move
Yes.
that we pass the levy of the common property tax
Do I
as
have a-
presented to us this year.
Have a second.
I would second that.
Any more discussion? All in favor, please. Motion passed. All right, let's move on to the budget. Now, anybody that was here on Wednesday got a preview of Jody presenting the budget for this year in its new form. Now, anybody that hasn't seen the form, this is the new form. It's in a spreadsheet, and it covers every department that we have here. She also went further back and did it for the last year, And this meant powering through back records for 5 years, was it? 5 years to put all this information together and make a reasonable budget that everybody can read and understand by just glancing across the page for each month. So I would like to entertain a motion here for the approval of this budget.
I move that we approve the budget as presented for fiscal year 2012, 2013.
I second that.
Any discussion?
I don't agree with putting the projected assessment increase, including it in the budget.
Which item, Roby?
It's the last item on the administration income on the first page.
Yeah, projected assessment increase.
It's simply a projection.
That's all it is, just a projection.
It's just a projection.
It's not an actual figure.
I realize that, but it leads us to believe that, you know, I don't want that number to be in there and then everybody thinking that we're going to get that money when we may in fact not. That's my opinion only, I mean, but that's, I don't want to include something in there that we're not sure we're going to get.
I understand. Any further discussion?
Is it appropriate to, would it be inappropriate to bracket or is, let me ask, if I may, sir, ask a question of Geo Stevens. Is there a way that we can accommodate Director Roberson's concern by maybe
Extracting it, if you extract it, then you might as well go ahead and extract the possible income for renters. I mean, that's $88,000 we'll take out of our bottom dollar projections. So you take the $190,443 that's projected to profit next year and minus $88,000. So you're looking at about $110,000 that you'd be profit without those two line items. And the only other thing, whether it comes or it doesn't come, until we hear back from the city, there'd probably be no other choice but to do some type of assessment, to put in an escrow fund for future digs. So there's a lot to consider. This is just you know as well as I know, it's just an outline of something to follow.
it's a working tool,
Right.
right?
This-
It doesn't,
Right. This budget is a work in process, and it's going to change as the years go on.
And you can leave it, whether you decide to, it's just gonna be a difference of $88,000 in projected income with the two.
How can you approve a work in progress?
It's a work in progress, and since you weren't here on Wednesday, which I wish you really were here, to put this into perspective, I went back 5 years of data to put this in, to formulate something right here,
I understand
okay?
this.
So a work in...
But you cannot approve a budget that is a work in progress.
okay, let me rephrase it, please. It is a tool, and that's what a budget is, in my understanding. It
It's a
is
tool.
always a tool. It is a prospectus. It is an organizing principle. It is many things, but it cannot, as a prospectus, be considered absolute and infallible in my estimation. Now granted, I am not trained in accountancy, but, you know, how could it ever be more than a prospectus?
That's fine. That's fine. Just leave it there.
Are these available to the general membership?
Not yet.
Beg your pardon, what'd you say?
Is this available to the general membership, the projected budget?
Not at the present right yet, but it will be. We have a first and second?
Pardon me?
Do we have a first and second? You made the proposal. Did you make the second? Yeah. We did make a motion. And we did a second. All in favor? Motion carries. All right. Next item is discussion, consideration, appointment of independent auditor for FY 2012-13. No, that was the other one. There's no, there's no paperwork,
No, sir, I didn't have it, I don't have anything.
What are you gonna do? Just call them up, or you wanna take it?
No, I don't see that, I just want to just wait till after our executive session discussion. So let's maybe table this one, until we hear what it's being said in executive session.
All right.
Okay?
All right. We'll table it until we come back from executive session. Now we'll go to the 15-minute Amber. Excuse me. Discussion. Comes first. What you think? One other individual also applies to the second. First name on here is, Mary.
Oh, I think you may have answered my question already.
Oh, good. You don't have to get
Well,
up
I
there.
do have a question. Don't you have to have a motion to table something that's on the agenda?
Yes, we do.
So, anyway, you didn't do that. But,
No, I know it.
My other question, I just have a comment. Either we call it the special assessment for common property tax, or we call it a special assessment to pay what we owe because we're in the red. Either way, we gotta pay it, right?
No.
So, but it does need to be legal, because we don't want somebody raising their ugly face in our face and threatening to sue us.
True.
So one way or another, I would like for you guys to figure out whether we're calling it the legal thing, or whether we need to change what we call it and still charge it. Right? I mean, we pay when we get to the end of the year and we owe money that we can't pay, you send out a special assessment. So you get to the end of the year, you send out a special assessment. So maybe it can just be called that. And then it's legal, right? Or not? Or is a special assessment not legal?
Well,
So anyway, that's my comment, my question.
Oh, wait a minute.
On the tax question, is it a question of the actual tax, the way you're taxing it by the percentage rate, or is it what it's being called that's really in question?
I think
Because Bill Hahn was a board member. We still sent out those taxes when Bill Hahn was a board member. So is it the question of what you're calling it? Is it the way you're taking the percentage to present it? Or what is his real concern?
Do I have permission to read an excerpt from this? Would that be?
I don't think it's the tax itself. It may be what you're calling the tax, or the way you're presenting the percentage of what you're putting to the membership.
Okay, the answer to the bottom line is, it's been considered what Janelle said, you go back to the 8,000, that percentage.
Correct.
Okay, that was one way of doing it. The other part of the topic is, it was considered which pieces, meaning grounds, buildings, etc.
But nobody but a taxing authority can actually say they're charging a tax. That is true.
Right.
So if you're calling it a tax, you can't call it a tax. Because nobody but a taxing authority can actually charge a tax.
When we get the bill, what is it called?
Tax assessment.
It's called a common property tax.
It's called a tax,
but
That's
it
all
could also be
right.
called
Yeah.
it could be called a special assessment. Now, the tax assessment that we've levied for many years is totally separate and apart from the special assessment that was levied last year
Right,
because we
we know
had a
that.
deficit.
Right.
So those are two separate.
Yeah, that was,
However you do it, you have to do it to where you still understand it's this assessment for the levy of the tax, but you can't actually call it a tax.
Yeah,
Because
both.
only a taxing authority can charge it and collect the tax.
Because when you send out the notice, you're calling it a common property tax.
Now, if that's the question, that is really legitimate concern.
Right. I'm looking here and it says 2011 Common Property Tax Assessment. So if I understand you correctly, Debbie, if we called it a common property assessment, we'd be legal, as long as we excise the word tax?
I believe so. That's what I have been told by the taxing authority, myself.
There's more to it than that because he thinks
Yeah.
it needs to be judged on the club grounds.
Correct.
That's
Yeah.
another part of the.
The whole argument, yeah.
Now, I know the one year that they reassessed the percentage that they charged the membership, and that went down almost half of what it had been charged in the previous years, when Bill Hahn was on this board. It went down from 22 or 24 to 11. And I knew that was a big concern the next year.
Right, I think that ended up helping us put in the deficit the next year because we got half enough money to pay for we paid for the grounds, but then the fort had to pay for the buildings. And all the money the fort gets comes from the members, so.
yeah, it doesn't change anything.
Either way, we're gonna pay.
Right, we're gonna pay it.
Exactly, either way you're gonna pay. What you call it is the crux of what she's
That's
talking
his
about.
issue, is what we're calling it.
Right, exactly.
I think we need to rescind that motion saying we're gonna levy for a property tax.
We haven't changed terminology on there. We're still doing the same terminology. Until we figure this out some later date, that's another one of those things that he's talking about. You know, and
What area are you talking about for this common property tax?
we just
Are you
discussed.
just a historical district, or?
No, we just was talking about just recently. You didn't
You
hear
never
it?
specified what, I don't know what area we're paying on.
All areas.
The common ground.
Common grounds.
Common ground only.
Yeah.
Okay, so we're paying for all the green area in all the units?
Mhm.
Common ground.
Okay.
Yeah.
Is the golf course included in that?
No. Yeah,
It is.
it was, but
Okay.
uh, Jack Howard?
The last one?
No, it's the next name I called.
I was just looking at this financial statement, and it's for 11 months of a 12-month period. So it's fairly close to what we can project we're going to be spending next year. So I was talking about budgets as being tools to go by. And I was looking on here and what was budgeted for 2012 and what we're actually spending per month is way out of whack. I mean, I don't know where anybody's alarmed about this as I am.
Yes.
But, you know, it's kind of ridiculous that when you look at what you budgeted and you're spending way over what you budgeted, something's wrong. So what does it tell you? You need to learn some way to control costs. I'm just wondering, what are we doing in 2012 and 13 to control some of these costs to make sure we don't keep going over the budget that we adopt? And, I mean, there's no way we can continue to operate because every year we're going to have special assessments. We're on the same track this year as we was last year. We should have learned from last year, which we didn't. We're on the same track this year. We're going to have a special assessment again. There should be some flags through the years that's raised, you know, that's telling you all that. So you need to look in the future to see how can you control the costs. I see administrative costs are way up, maintenance expenses are way up. I mean, and there's ways to control that.
Can I answer the
The
question?
thing about it is, let me.
Okay, go ahead.
Everybody knows that y'all are on a fixed income. You get so much per month you get for assessments. So you know how much you have to spend. Only thing you have to project is how much you're gonna get from the motel, how much you're gonna get from the RV park. And factor that in. So you should have a pretty good idea of how much money you have to spend every year. So you should be able to allocate that money between the different departments. And if they want more than you have, tell them you can't have it. You have to work within your budget. A budget is not just a tool. You know, you say it's a tool, but it's not. It's a description of how much money you have to spend and where you're gonna spend it. That's what it is, what a budget is.
Right.
And you need to stick to it, stick by it.
Right.
And if you keep going over every month, then you as the board should run some flags up to the departments and, hey, you guys are overspending, you need to cut some costs. You may need to cut personnel, you need to cut some of the stuff you're doing, something's gotta go. You can't continue to keep going up.
I understand exactly what you're saying, and that's why we have this budget the way we have it this year. And Jody realizes that too, and she was put in the position that she had to come up with something that addresses these issues that you're talking about, and we have to bring them under control. And that was the idea of getting this, so we have a better picture. But what you were holding and what we used to see was just a page or two, and it didn't give us the information to see where everything was going, or how it was spent, or anything like that. This is a better tool right here, because it gives us a heck of a lot more and tells us every department.
This is what the members see, and it doesn't look very good.
I understand that. I'm not refuting what you said.
I know.
I understand it.
Understand.
Anyway,
They were saying the budget was a tool, but it's not. It's really something you need to stick by. It's not something.
well, it's both. It is a tool and something you have to stick by too.
The budget we approve is one we should stick by.
Right.
And we're legally bound to
And you
stick
don't-
by it, I
you don't
would
go
feel like.
You are.
Yes, you are.
I'm gonna address this, and again, these are, it's kind of, we're taking a step back. Wednesday, we addressed all these things. Your current tool, which is an archaic system, we all know that, and that's what you see right there. So that's why I painstakingly took every month that we get and they get and put it side by side, broken out line item by line item, how it is. Then I took an extra step and did your audits for the past 5 years, line item by line item, what Randy gets to see, our auditor, and put together an average, okay, to come up with some simulation of consistency. Because how it is, you're right, you see the peaks and valleys, but you can't see it until you map it all together in the way I've done it here for the board. Now, when you sit there and you go month by month, and a line item isn't the same as the month before, in our archaic system, this is what I've created to merge the old world with the new world. So every month, me and my accountant will have to go painstakingly and take the information from the old world and compile it here. And they can see month by month the consistencies and the peaks and the valleys of the budget. Now, where this is gonna, your bottom number will end up the same this year, because in the past, because we've gone through lots of different people touching our account, our banking system, in the past 2 years, I have about 3 different people in there, okay? So obviously, every person doesn't work the same. So one person might have been allocating maintenance electricity and all general admin, as opposed to, we do have a meter down at maintenance, and I can see what exactly maintenance cost me in electricity. But somehow it got shoved here this month and then back allocated over here the next month, so you really can't see, oh, maintenance, you need to take out some 100 light watt bulbs, why can't I speak, and put in maybe 40 watt light bulbs. So these are the things. I've already taken this tool, because currently our department heads don't get anything like this.
That's what I'm saying.
Okay, so I'm creating
Why haven't
those
we do
tools.
stuff like this in the past? Why is it just now happening?
And then we're moving forward. And I can't
Good
tell you
question.
why it didn't happen. They can't tell you why it didn't happen in the past.
Good
They're a
question.
new board. We are working together to make this more streamlined and hold
That's the
accountability.
whole thing.
And so what you're looking at is the projections from a very simpler budget presentation that, you know, it worked maybe okay in certain, I'm not sure it did, but anyway, pardon me?
I'd like that.
Yes.
And you
Okay,
can't even go
I know
off
it's
what
very
this
simple,
year
very
is,
friendly, but it's
Oh.
not
because
very
this year was exceptional, because of
Okay.
the RV
We
park
had
and the
RVs.
motel.
Whatever.
So you just couldn't base it off this year's figures.
Next
Because-
next person on the list is Is it Dean?
Dean,
Dean.
yep.
Did you have your question answered on the 209-002 by the gentleman that was here, or do you need
Yes,
more?
the attorney answered, yes.
Did he?
Thank you.
Okay.
He said that the state law supersedes the protective restrictions.
And sir, I will go back and I will pull my copy of that and I will read it and I will try to understand your point of view, and I will.
Okay. That's all the names that were on the 15-minute.
15-minute break.
Right. Yes. Can I have a motion here to table this discussion and consideration on the auditor?
I move that we table the discussion for the appointment of independent auditor until we come back from executive session.
Do I have a second?
Second.
All in favor? Motion passes. All right, the time is now 11:26. We're going to break to go to executive session.